Okay, we are winding down our break, and I see our next panel is getting ready to join us. For those of you who may just be joining us now, welcome to the Rothgerber Conference. We're really excited to have you, and we've had some really powerful programming this morning, and so we're looking forward to keeping this conversation going. We're going to go ahead and get started. I do want to remind people that if you'd like to see what's happening next, the program is available for you in the chat. So you're welcome to go to that link and get some more information. I'm encouraging people, if you have time in your schedule and you're really inspired and want to contribute and participate in the conversation, about 4 o'clock Mountain Time, we're going to be doing a virtual reception. And we'll be doing breakout rooms. And that's just a chance to give everybody the opportunity to have more sort of interaction on an informal basis, maybe to do a deeper dive on some of the issues that you've heard about today, or learn a little bit about how you can take action, right? We will be doing a lot of learning. And for some of you, you may feel like you want to do something concrete, whether it's related to policy or art or rallies or whatever the case may be. There are a number of people who are working hard when it comes to immigration and citizenship issues, and you may want to learn a little bit more about how you can get involved. So that is going to be happening later on. At this time, I want to welcome everyone back and introduce the moderator for Panel 2. Panel 2 is going to be covering citizenship, integration, and belonging. And I'm really happy to see our moderator, David Cook-Martin. David, welcome and thank you for agreeing to moderate this wonderful panel today. Professor Cook-Martin is a professor of sociology at the University of Colorado in Boulder. And this is something I talked about before. We have such an amazing interdisciplinary group of folks that are talking about these issues. So I so appreciate that. Professor Cook-Martin's work as a political sociologist focuses on understanding migration, race, ethnicity, law, and citizenship in an international field of power. His work geographically focuses on the Americas, but also on Southern Europe. He holds a PhD in sociology from UCLA, a master's in sociology from University of Houston. He has taught at NYU and also Cornell. And at Cornell, he was assistant vice president for global education and director of the Institute for Global Engagement. So at this point, I would like to turn over this portion of the program to David to take it from here. Thank you very much to all the panelists for being here, and we look forward to your remarks. We also will have Q&A. So for those of you who would like to participate, you may go ahead and post your questions in the Q&A function. If you are part of the webinar, for those of you who are joining on the live stream YouTube, you won't have that option, but we appreciate your being here. Right, thank you. Professor Cook-Martin.
Thank you, Professor. Wow, I'm still feeling the power of Alan, Cheyenne, and Salvador's stories, and those of the people we heard from last night. These are stories familiar in many ways to my own families, but they remind me that as we move between the personal and the 30,000-foot view, we need to keep these stories together with those broader views in our hearts and minds. So welcome everyone to this panel entitled Citizenship, Integration, and Belonging, which is inspired by Professor Chen's wonderful book on pursuing citizenship. I too want to thank her for writing it and for generating the kind of dialogue that we've seen here today. If we take seriously Professor Chen's ideas of newcomers to the nation being arrayed across a spectrum of semi-citizenship, to also invoke Professor Cohen's work, we can expect a range of pathways toward fuller citizenship. We can expect bifurcating pathways and even truncated pathways. This panel explores some of those pathways and how different actors, individuals, as well as other organizations and states think about those pathways and act on those thoughts. If you are interested in the background, you can check out chapter 3 in Pursuing Citizenship, which you can see over my right shoulder there. Specifically, we may expect that immigration and citizenship policy will reflect tensions between the realities of citizenship as spectrum and national imaginings of the US being a nation of immigrants. We may expect that organizations other than the state will recognize the challenges of national policies to the realities of a geographically mobile labor force, and that they will adopt to their own strategies of belonging in a particular place and time. And finally, countries will continue to adapt the tests that they use to allow formal membership in their jurisdictions. So our distinguished panelists, whom Nick Steverson will introduce shortly, will take on the range of these questions, starting with the US case and then considering some other country cases. A very quick word on logistics. As you know, and as Professor Malveaux just pointed out, you can introduce questions into the Q&A, and we'll try to get to as many of those as possible, but we may run out of time or we may combine them. For the panelists, I'll give you a 3 and 1 minute old school warning at the 10 and at the 12-minute mark. So let me introduce briefly Nick Steverson, who is a second-year law student at the University of Colorado. He is pursuing a career in civil litigation with particular interest in complex litigation, consumer protection, and constitutional issues. He grew up in Denver. He attended college at Bates in Maine, where he majored in English and minored in Latin. And after college, Nick returned or stayed on in Maine for a couple of years teaching, and then returned to Denver before starting law school. And since starting at Colorado Law, Nick has interned for the Denver City Attorney's Office and the Colorado Supreme Court, and will join Wheeler Trigg O'Donnell LLP as a summer clerk in 2021. Nick is an articles editor for the Colorado Law Review and a member of CU's AAJ and All-Star National Mock Trial teams. Outside of school, Nick enjoys hiking and playing guitar, particularly Neil Young's acoustic songs. Welcome, Nick.
Thank you, Professor. As you mentioned, I'm an articles editor for the Colorado Law Review, and on behalf of everybody at CLR, I just want to say that we're so excited to have these panelists join us and are grateful for their time and for the conversation that we're about to have. We have 4 panelists with us today, and I'll introduce each as they're about to give their presentation. First, we have Professor Tomas Jimenez. Professor Jimenez is a professor of sociology and comparative studies in race and ethnicity at Stanford University. He is also director of the undergraduate program on urban studies at Stanford. His research and writing focus on immigration, assimilation, social mobility, and ethnic and racial identity. He has written 2 books, The Other Side of Assimilation, How Immigrants Are Changing American Life, and Replenished Ethnicity, Mexican Americans, Immigration, and Identity. Professor Jimenez has also published his research in Science, American Sociological Review, American Journal of Sociology, Proceedings of the National Academy of Sciences, and a number of other journals in sociology. He is currently a Stanford Impact Labs Fellow, developing relationships with community partner organizations that will ultimately serve as collaborators in the research on immigrant integration. Professor Jimenez is also taught at the University of California, San Diego, and he has been named a Sigma Chi Distinguished Lecturer. He has also been an Irvine Fellow at the New America Foundation and a Sage Fellow at the Center for Advanced Study in the Behavioral Sciences at Stanford University. He was the American Sociological Association Congressional Fellow in the Office of United States Representative Michael Honda, where he served as a legislative aide for immigration, Veterans Affairs, housing, and election reform. His writing on policy has appeared in reports to the Immigration Policy Center and the Migration Policy Institute. He's also written opinion editorials on the topic of immigrant assimilation in several major news outlets, including the Washington Post, the Los Angeles Times, CNN.com, the Chronicle of Higher Education, and the San Diego Union Tribune. He has also offered commentary from media outlets, including NBC News, NPR, and Univision. Please welcome Professor Tomas Jimenez.
Thank you, Nick, for that generous introduction. And David, thank you for inviting me to be on this panel. And it's a real honor to serve on it with the other panelists. So my role on this panel, I think, is to do some stage setting and to discuss in sort of broad strokes what assimilation, integration, incorporation are, and then how that concept has been infused in policy, or really not been infused in policy, with some exceptions. And so I'll kind of march through that order right now. So the term assimilation is a loaded term, and it means many things to many people. I will use it sort of interchangeably with integration and incorporation. But the term gained popularity in the early part of the 20th century, and thereafter, the term had a social scientific life, it has had an ideological life, and then it has sort of had a policy life. The social scientific life of assimilation starts with the study of the Southern and Eastern European immigrants who came to the United States around the turn of the 20th century. They came overwhelmingly from Southern and Eastern Europe, and sociologists turned to the immigrants who were settling in their own backyard in places like Chicago and New York in particular, to try to understand a host of questions, including how different groups of people defined it in the term that they used then by race, the term that we use more popularly now, ethnicity, how they kind of came together and potentially formed a common social, political, and economic life. And the theory that developed, the social scientific theory that developed thereafter, suggested that as immigrants and their descendants spend more time in the United States, they gain upward mobility. And with that upward mobility comes greater interaction with people from different racial and ethnic groups. Other kinds of processes attain the diversification of social cliques, intermarriage, et cetera, and you have a population that starts to look more similar. The ideological life of assimilation that followed that social scientific life was prescriptive, and that it said that assimilation was a good thing, that immigrants and their children and grandchildren should give up the ways of their old world ways, and I put that in air quotes, and quickly become part of an American society defined by Anglo-Saxons, by Protestants, and a sort of middle-class way of life. And so as we move through the 20th century, both the social scientific and the ideological lives of or aspects of assimilation fell out of favor. The social scientific life fell out of favor partly because there was a rapid decline in the number of immigrants arriving in the US after the mid-1920s, and really didn't pick up again until the 1970s. And then ideologically, assimilation fell out of favor because it was seen as a sort of prescription for people getting rid of ethnic distinctions in the middle of the 20th century, at a very time when the emphasis was much more so on sustaining, or I should say there was a renewed interest on sustaining, on celebrating ethnic difference. But demographic change forced folks to return to the ideas of assimilation again, beginning really in the 1980s. By that time, it was clear that we were in the midst of a new surge in immigration to the United States, this time not from Europe, but overwhelmingly from Asia, Latin America, and to some degree from the Caribbean. And so scholars started returning to the idea of assimilation, but this time recognizing that immigrants who were coming to the United States were quite diverse. They were diverse with respect to their origins, including from an American perspective, their racial and ethnic origins, but also in terms of their class standing. And it was becoming clear that the United States was growing increasingly diverse in terms of its own racial and class profile. And so scholars started to say that immigrants weren't assimilating to a monolithic American society, but rather into one of many segments of an American society that itself was divided by race and class. But there were some of us who were still wanted to resurrect the very old ideas of assimilation in some ways and see if we could take the components of it that were quite useful and fashion newer ideas about assimilation that weren't necessarily focused so much on the immigrants, but more on a kind of holistic sense of American society. And so folks like Richard Alba and Victor Nee said that as immigrants assimilated, they weren't just giving up their old world ways and leaving them behind and becoming like some monolithic mainstream. Rather, as immigrants assimilate into the mainstream, they said they are changing the very notion of the mainstream itself. Nick mentioned my most recent book, which tries to apply some of those ideas in a kind of real world context. And I studied my own backyard here in Silicon Valley and focused on people who were not immigrants or the children of immigrants, or even in most cases, the grandchildren of immigrants, but rather settled populations, and tried to understand how they were adjusting to contexts that had been dramatically changed by immigration. And the upshot is that assimilation is not a one-way street. It is a process of give and take, of mutual adjustment. And over time and across generations, that mutual adjustment often results in radically changed notions of racial belonging, of ethnic belonging, notions of the national character. And I think that's kind of where we are with assimilation theory. I haven't said much about policy and its relationship to assimilation, as you may have noted. And that's because the United States has not historically had an immigrant policy. We've had an immigration policy, and the way in which we admit immigrants to the United States, the legal circumstances under which they're admitted, and under which they are allowed to become citizens certainly has implications for the kind of assimilation processes that I've talked about, but it's really been absent from the policy scene. And fears about assimilation have certainly animated our immigration policies. If you read many of the great histories about the 1924 quota laws that shut off, basically closed the door to European immigration, they were motivated by fears of assimilation. But I do want to pick up the policy piece and focus it in a little bit on what's happening today, because I do think it's the case that the United States continues to not have an immigrant policy, one aimed at helping immigrants integrate. There are some exceptions, the main exception being with refugee policy, where we do have actually a pretty robust integration program, but otherwise we don't at the federal level. But that doesn't mean that the state, broadly conceived, is not doing anything about integration. In fact, states, counties, and cities have been heavily engaged in immigrant integration policy in the last 20 years. For a good period of that 20 years, from the early part of the 2000s up to about 2012, the majority of policies that were passed were what you might describe as disintegrating policies. They were designed to cut off access to rights, resources, and institutions for immigrants who were settling in places like Arizona and North Carolina and Alabama and Farmers Branch and to Escondido, to name a couple of cities. But after 2012, the policies became overwhelmingly welcoming. They were meant to expand access to rights, resources, and institutions. And that trend actually even continued during the previous administration, where policies were becoming more welcoming. They were meant to expand access to rights, resources, and institution, and as some recent scholars have noted, perhaps offer up a more kind of localized form of citizenship, not predicated on what the federal government bestows on immigrants in terms of their ability to belong to the polity or not, but rather on a notion of citizenship that operates in cities and counties and states. And the policies have been meaningful. They have done things in the state level, like offer driver's licenses, in-state tuition and in-state funding for immigrants regardless of their legal status. Counties and cities have developed offices of immigrant affairs that do things like expand access to English language acquisition, that do workforce development, that offer leadership programs to help immigrant communities become better engaged in local government, that offer ways for local emergency responders to have more trusting relationships with immigrant communities. And that is really where immigrant policy is going in the United States. That's where the action is. And it's not just that that's where the action is, and it's not just that it has a meaningful impact on immigrants. The impact, I argue, is broad-based. I've done some research in Arizona and New Mexico, and also in the United States more generally, with Debbie Shielkraut, Jack DeVideo, and Yen Ho. And we were interested in the effect that perfect. Thank you, David. We were interested in the kinds of policies, the social psychological effect that immigration policies or immigrant policies at the sub-federal level can have on individuals. And we were interested not just in the groups that might stand to benefit most, but also the groups that may have the least stake in immigrant integration policies. So we studied Latinos and we studied whites. And the upshot, using a range of methods from survey to experiment to in-depth interview, the upshot is that when policies are more welcoming to immigrants at the sub-federal level, there is a broad-based effect that on belonging for both Latinos and whites. Not surprisingly, perhaps, the overwhelming majority of Latinos experience a greater sense of belonging when immigration policies are more welcoming, but that's also true of the majority of white respondents, US-born white respondents, who would presumably have no stake in immigrant integration policy. And in fact, one might hypothesize that they would see a zero-sum game or a benefit for Latino immigrants or immigrants in general is a potential deficit for them, but that's not what we find. We find that there are political divisions of the sort that you might expect, but on net, immigrant integration policies, welcoming policies, create a greater sense of belonging for everyone. I'll stop there.
Thank you, Professor, for that. Next up, we have Professor Stella Burch Elias, who is a professor and Chancellor William Gardner Hammond Fellow in law at the University of Iowa College of Law. She teaches international law, immigration law, and comparative law courses, and she directs Iowa's London Law program. Her research involves public international law and comparative law with a focus on United States and foreign immigration and nationality law. Professor Elias earned her BA and MA from Oxford University and her JD from Yale Law School. After law school, she clerked for Judge Stephen Reinhart of the United States Court of Appeals for the Ninth Circuit. Before joining the Iowa Law faculty, she held a 2-year appointment as a Clemenceau Fellow and lecturer on law at Harvard Law School, and she also served as a diplomat in the United Kingdom Foreign and Commonwealth Office. Since joining the Iowa Law faculty in fall 2012, she has won several awards for her teaching, scholarship, and service to the university, college, and local community, including the University of Iowa's highest teaching honor, the President and Provost Award for Teaching Excellence. Please welcome Professor Stella Burch Elias.
Thank you, Nick, for that kind introduction. And thank you, David and fellow panelists for having this conversation. It's really a pleasure to have the opportunity to participate in this discussion, building on Professor Ming-Hsu Chen's important work in pursuing citizenship in the enforcement era. I am a huge admirer of this book for many reasons, including something that many of the previous speakers have highlighted, which is the deft and convincing way that Professor Chen's work challenges the long-standing and deeply misleading citizen-alien binary that underpins US immigration and nationality laws. And I think all of us would agree that there is indeed a spectrum of citizenship and belonging, or as Ming puts it on page 116 of her book, the substantive dimensions of belonging do not automatically emerge from formal citizenship and should not be contingent on formal status. And if anyone needed any further convincing of that, our lunchtime panel today, I found incredibly moving on that particular topic. And yet, when an aspiring US citizen, an American in waiting, to paraphrase Hiroshi Motomura, when an aspiring citizen takes her final steps on this winding path to citizenship, the United States government nonetheless attempts to assess her substantive belonging to the nation through the administration of a citizenship test. And the test itself, including its form, function, and its practical operation, is unquestionably warped or distorted, like all other aspects of immigration rulemaking, by the enforcement era in which we all live. And so that's the topic of my project that I want to talk to you all about today. And so in the time that I have today, I want to talk to you about the history of citizenship tests in the US, the Trump administration's introduction of a new version of the citizenship test on December 1st, 2020, and what I think that particular exercise means, and the Biden administration's reversion to the previous version of the test, which was introduced originally in 2008. I hope in the time that I have today, I'm going to be able to convince you all that while the 2008 test with which we currently live is a simpler and more accessible version, and therefore more equitable than the 2020 iteration, the Biden administration should not be stopping there by returning to a less bad, but still fundamentally flawed metric. I think we have a moment of opportunity here, as Professor Malveaux mentioned earlier. And so we have an opportunity to take a new approach to many aspects of immigrant inclusion and immigration, just as Professor Jimenez was talking about a moment ago. And so I think it's time for us to think critically about our national goals for assessing suitability for naturalization, to consider the lived experiences of the diverse immigrant community members who are contemplating becoming US citizens, and to promote the values of acceptance and inclusion through our approach to assessing civic belonging. And so all of this is a topic that goes far beyond the reach, of course, of the minutiae, the very technical issue of what is included in the citizenship test. And I've written about immigration federalism and refugee federalism and all sorts of attempts to integrate immigrants, but I find the citizenship test fascinating. And full disclosure, I've been fascinated by citizenship tests since I had to take my own English language and civics test in Des Moines, Iowa, back in 2014, when I naturalized as a US citizen. That experience in all its glory prompted me to do 2 years of comparative research into citizenship testing around the world and to write an article called Testing Citizenship, which I published in 2016 in the Boston University Law Review. So I am a citizenship test nerd, both because of their practical function and because of their expressive function. And so I was saddened, but not surprised at all, by the Trump administration's recent attempt to update the citizenship test in November 2020 as one of the many tools that it used to advance its anti-immigrant agenda. And so let me tell you a little bit to begin with about the background to citizenship tests. As you may know, the US was the very first country in the world to introduce a citizenship test as a prerequisite for naturalization. And as a matter of US law, in order to meet the substantive criteria for naturalization, you have to have a requisite period of residency in the United States. You have to not have any disqualifying criminal history. You have to demonstrate good moral character, et cetera, and you have to demonstrate to the satisfaction of an immigration official your knowledge of the English language and your understanding of the history and government of the United States. This all sounds very neutral and potentially desirable, but from the very beginning, citizenship tests have been used as a tool of exclusion for so-called undesirable migrants. The original test, designed by the economist Edward Bennis in 1887, was designed as a means of discouraging the often illiterate Southern and Eastern European migrants from becoming citizens in the United States. And each iteration of the citizenship test since then has sought to to discriminate amongst immigrants based on English language knowledge and has presented an ever more elusive and amorphous notion of American values or American character. And my analysis of the historical debates around the introduction of each new iteration of the US citizenship test suggests that American character is actually a flimsy euphemism for white American identity, that at the turn of the 20th century was fueled by animus towards Asian migration, in the mid-20th century was infused with anti-communist rhetoric, and from the mid-1980s onward has been influenced by anti-Latino sentiment. Of particular concern to me is the approach in the modern era, whereby every 10 years, the citizenship test has been reimagined and revisions have been introduced. And with the one exception of the Biden administration just now reverting to the 2008 test, it's essentially served as a one-way ratchet, with the test getting progressively harder and more exclusionary over time. The Immigration Reform and Control Act of 1986, which Professors Motomura and Chen discussed this morning in their opening conversation, standardized the administration of the citizenship test throughout the US and introduced more complex questions for would-be immigrants. And the newly configured test in 2008 was greeted by an uproar. Immigrants' rights advocates argued that this test would exclude less resourced immigrants, disadvantaged immigrants, poorer immigrants, because of its complexity. But these revisions persisted with increasingly complex questions about governmental structures and American history. And it included, for the first time in 2008, 100 potential questions. And so immigrants were told you must memorize 100 potential questions and answers on US history, national symbols, basic political issues such as parties, voting procedures, and the Constitution. And during the naturalization interview, the USCIS officer will orally ask the intending US citizen a series of questions, up to 10 questions. And the applicant needs to answer 6 questions correctly to pass the test. And the applicant also needs to write out a sentence in English with correct spelling, punctuation, and grammar. My own sentence when I took the citizenship test was, "The people elect the federal government." Pro tip for anyone watching this naturalizing in the future: turns out this is not the time to bring up the Electoral College and get into a debate with your USCIS officer. Don't do that. And so to prepare for this interview, USCIS provides all individuals who've applied for naturalization with a booklet called Learn About the United States, Quick Civics Lessons for the Naturalization Test. And the booklet contains these questions. Until 2015, the booklet and all of the test preparation material was only available in English. In November of that year, in response to a recommendation from the Obama administration's Task Force on New Americans, a Spanish language version of the questions was provided. But if you were not an English speaker or a Spanish speaker, it was incredibly difficult to obtain materials that would help you prepare for the citizenship test. And that deeply flawed test in 2008 that received tremendous criticism from immigrants' rights organizations and immigration advocates, served as a check on people applying for naturalization for a very long time. I myself in Iowa volunteered with my law students at a number of citizenship drive events, and I lost count of the number of immigrants I spoke to who were deterred by the test from applying for naturalization. So my own anecdotal experience, of course backed up by empirical studies, showed that it did serve as a check and a barrier to naturalization, particularly among traditionally disadvantaged immigrant communities, until, as Professor Chen's book discusses, first the aggressive Trump presidential campaign, and then the Trump administration created such a degree of fear, insecurity, and instability amongst the previously relatively stable LPR, lawful permanent resident, population in the United States, that individuals who had resisted applying for naturalization because of fear of the content of the test came forward, and interviews with individuals who were previously hesitant about applying for naturalization because of the test said that the fear of what might happen to them if they weren't able to naturalize pushed them through their fear of taking the test itself. And so, as Professor Chen's book explains, citizenship naturalization applications increased remarkably. And so it came as no surprise to me and my colleagues that in response, the Trump administration used its review of the citizenship test to work out how to make the test harder. And its parting gift in November 2020 was a new citizenship test that was insurmountably challenging on its face. The 2020 test drew from 128 possible questions rather than 100. And prospective citizens, instead of needing to answer 6 questions out of 10, were now required to answer 12 questions out of 80 correctly in order to pass. And the test administration itself was designed to take twice as long. 40 out of the 100 questions on the test remained unchanged from the 2008 version, and the rest were reworded or newly introduced. And the questions themselves became much more complex, eliminating simple questions about geography and adding dozens of possible questions with complex phrasing and nuanced answers designed to trip up applicants, especially those with limited English language proficiency. One question even required a basic understanding of Latin. The nation's first motto was E pluribus unum. What does that mean, was the question. Quite how that's relevant to contemporary life in the United States. This immigrant was unsure, but nonetheless, that was the question. And the answers to some of the questions were also reworded to serve as concrete expressions of the administration's particular conservative agenda. The answer to the question, who does a US senator represent, for example, was changed from all the people of a state to the citizens of a state. A question about the 10th Amendment was added, presumably for people who become very exercised about states' rights. And a question was added about the Vietnam War. Why did the United States enter the Vietnam War? With the infuriating correct answer of to stop the spread of communism in the world. In short, the 2020 test substantively was designed to be longer, harder, and more intimidating. And it was clearly also designed to serve the twin goals of deterring individuals from applying for naturalization in the first place and of slowing down the naturalization process. It's simple math. If it takes twice as long to administer a citizenship test, you can only naturalize half the number of citizens. And so the wait list doubled from December 1st, 2020, when the new rule was announced, until March 1st, 2021, when the Biden administration reintroduced the 2008 test. And so, of course, to the great relief of us all, the Biden administration has reintroduced the 2008 version of the citizenship test. And as I mentioned at the start of my time, that's a relief. But I also think that it's not good enough. I think that if the United States as a nation wants to demonstrate a commitment to welcoming immigrants and to the twin values of diversity and inclusion, then it's time for us to learn from the lesson from countries all around the world that have also grappled with this issue and to consider fundamentally overhauling the citizenship testing regime. And so my time is up. Thank you very much for allowing me to speak about this. There's a lot of work to be done.
Thank you, Professor. Next, we have a co-presentation with Professor Shannon Gleeson and Professor Xóchitl Bada. Professor Gleeson is Associate Professor of Labor Relations, Law, and History at the Cornell ILR School. She earned her PhD in Sociology and Demography from the University of California, Berkeley, and was previously on the faculty of the Latin American and Latino Studies Department at the University of California, Santa Cruz. Her books include Accountability Across Borders, Migrant Rights in North America, Building Citizenship from Below, Precarity, Migration, and Agency, Precarious Claims, The Promise of Failure of Workplace Protections in the United States, The Nation and Its People, Citizens, Denizens, Migrants, and Conflicting Commitments, The Politics of Enforcing Immigrant Worker Rights in San Jose and Houston. Professor Bada is Associate Professor in Latin American and Latino Studies at the University of Illinois at Chicago. Her articles have appeared in Forced Migration Review, Population, Space and Place, Latino Studies, and Labor Studies Journal. She is the author of Mexican Hometown Associations in Chicago, Ilkan. Her areas of specialty include migrant access to political and social rights, migrant organizing strategies, and transnational labor advocacy mobilization in Mexico and the United States. She is co-editor of the books New Migration Patterns in the Americas and Accountability Across Borders. She was also a fellow at the Institute for Advanced Study in Berlin from 2019 to 2020. Please welcome Professors Gleeson and Bada.
Thank you, Nick. I appreciate the opportunity to be here and just want to extend my gratitude to my colleagues in Colorado and all the staff working behind the scenes to make today possible. It's a real pleasure to be talking about Ming scholarship in conversation with our own. I have had a long intellectual journey with Ming as we went to graduate school together. And even though we come from different disciplinary backgrounds, we have a lot of shared interest around the issues of citizenship and belonging. And so I wanted to take a bit of a departure from this work, from the current conversation we're having, and to introduce you to some of the themes that my co-author Xóchitl and I have been thinking about. And a lot of the ways that we've been thinking about citizenship so far and in today's panels has been about belonging and citizenship bounded by the nation state. And this idea that the nation itself, the nation state itself is the bounded arena of claims making for these rights, both the creation of these rights and the processes of making claims on them. And so I want to do two things today. One is to push us beyond the nation state as we think about rights and belonging. And the second is to intersect meso-level analysis to this and thinking specifically about the role of civil society in brokering these rights, which is a key theme of a lot of the work Xóchitl and I have been doing. And then rather than think about this in a kind of an abstract cosmopolitan way, which I think a lot of work of political citizenship has done, I want to argue that this is a factor that is playing into how nation states are thinking about their diasporas and their migrant populations, which are not necessarily in a limbo, as one of the panelists during the lunch session talked about, but rather de aquí and de allá. In other words, here and there simultaneously, and what this means in terms of mobilizing rights and implementing those that are already in the books and placing them in actual practice. And so what we're going to do today is talk about one of the chapters from our book in progress, which is under contract at University of California Press, and think about the role of civil society specifically in a transnational context in terms of helping to mobilize these rights. And we know that many of these, what we might refer to as diaspora serving organizations, are critical to migrant rights advocacy. And they've been doing so in a number of different ways, both in terms of social movement context, across borders of organizing, around human rights, et cetera, but also against the backdrop of a lot of bilateral conversations in terms of free trade. And this is not a labor conference, but those of us who are doing work in the migrant labor arena, including David, know that this has been a key component of how we think about and conceptualize rights beyond the civic and political arena. And so we want to understand that in the context of mass displacement, how can we decenter the rights framework from the nation state, and to highlight in the few minutes we have today, what are the different ways this is happening? And so I'm going to talk about this for a few moments and then hand it over to Xóchitl to tell you about our findings. But first, I just want to kind of contextualize this in the context of the work that Keck and Sinkink did on transnational action networks, where we tend to think about, for example, nonprofit organizations or NGOs working with other NGOs in other states to target external pressures, say, for example, pressuring the European Union to then force, say, Honduras or some other place where there might be a maquila doing production work to respect their labor rights. And the transnational advocacy network that we tend to think about in this classic framework of the boomerang effect assumes that there's a single target which you might be navigating through an external ally. But in this case, we argue that in the case of Mexican migration to the United States, there's actually a dual target. In other words, we have transnational and cross-border organizations which are targeting not only the US to pay heed to the rights of migrants, but also to Mexico as both a sending state as well as a transit state. And I'm going to talk a little bit about that. And we're going to highlight this in the context of what many of these organizers have called a portable justice framework. In other words, this idea that rights are not bound by the nation state. And this idea emerged primarily in the context of social welfare entitlements of older migrants, pensions, et cetera, but now it has encompassed not only the rights of immigrants who have left, but also those who have returned either of their own volition or due to mass deportation, and also thinking about economic justice and the right to stay home. And the issues of labor abuses, which we are primarily focused on in our work, is not nation state bound either. In fact, especially if we think about the role that recruiters play and the cross-border ways in which restitution can be offered, these civil society actors continue to play a really important role. The rest of the book focuses primarily on the history of consular engagement. This is work that has been done by a number of other scholars, including David Fitzgerald and Ale Delano. And where we kind of fit into this is thinking about the role specifically of the consulate as an institution in the process of co-enforcement. And we're very interested in the very particular agreements that have emerged between, say, the SRE, the Foreign Ministry in Mexico, as well as the Department of Labor in the United States and other federal agencies. And so our work includes not only a national level analysis, but also in the United States, talking to a number of organizations across the country who have taken part in this annual effort to try to implement the rights of especially low-wage workers for migrants, which in US labor law, for the most part, with some exception, all workers are eligible to things like wage theft protections, et cetera. And Mexico is not alone in doing that. There are a number of other countries who have followed suit, but we have been interested in how this plays out, not only amongst the consular corps, but in their relationships that they're forming with local agencies and local civil society. And this really represents, as others have written about, a real shift in Mexican policy towards their immigrants as new policies have been developed to quote unquote manage the diaspora, but also as labor advocacy networks have become more sophisticated in terms of mobilizing their claims, both against the receiving context, but also the sending state itself. And so we've been interested in looking at this and wanted to share some of what we found about the efficacy and also the challenges being faced as they pursue these dual target strategies. And so our research in this chapter is really about trying to understand what are the factors that contributed to this shift to a portable rights framework, and also how these coalitions are coalescing across borders and how they're strategizing around the various challenges that Xóchitl talked to you about. And again, if we take Mexico as a case study, it's understanding its accountability not only to the diaspora, the majority of which are in the United States, so not exclusively, but also to the workers who remain or who return, and to increasingly the southern border of Mexico and the Central American migrants themselves, who have begun to also make claims on within a human rights, but also labor rights framework. So in this context, we won't belabor all the different statutes that are relevant here, but we've had to really become familiar not only with US labor law as it relates to immigration, which is primarily what we've been talking about today, but also the various instruments of global governance at the level of the UN and the ILO, bilateral agreements like NAFTA, like the USMCA now, CAFTA, et cetera, and those labor side agreements that have emerged. And many critics would say that these are just symbolic instruments that don't actually really produce much. And while I'm actually very sympathetic to that argument, what we have found is that the petitions that have been filed actually represent a very particular legal advocacy strategy, as many of you, your colleagues at the law school will attest, that provides other openings in the social movement realms. And we've been really interested in how these different strategies get shared amongst laterally different civil society groups, and how this has produced at least modest returns in terms of accountability. Just to tell you a little bit about the data, and then I'll hand it over. I won't belabor it, but you can see here the different data points, which include some archival data, as well as work interviewing. I forget our number, so you can remind us how many interviews we now have. Of about 100. We have close to 200 interviews, but today we're going to focus on the red. We're going to focus specifically on the petitions and the different legal strategies that these transnational actors have taken, and specifically focus on the Mexico City-based diaspora-serving transnational organizations and those who have, in some cases, also created a footprint in the United States. There are many other kind of civil society groups that we also have talked to, but that will be our focus today. So let me go ahead and hand it over to Xóchitl, and just let me know when you want me to change slide.
Sure, thank you, Shannon. And now we will quickly highlight from the set of interviews, which are like a smaller set of 20 or so interviews, we are going to highlight 4 organizations in our interviews that have actively promoted a portable justice framework by deploying transnational labor advocacy networks and leveraging the NAILC, the North American Agreement on Labor Cooperation. The first one is Justice in Motion, formerly Global Justice Workers Alliance. This organization has extended its presence now to Mexico, Guatemala, El Salvador, Honduras, and Nicaragua, using a model of transnational defender network of human rights lawyers and non-profit organizations. Then next comes the Centro de Derechos del Migrante, CDM, which begins in Zacatecas and now has offices in Baltimore, Mexico City, and Oaxaca. CDM pursues an innovative transnational approach. It provides migrant workers with training and legal advocacy in their communities of origin. Then next comes PRODESC, the Proyecto de los Derechos Económicos, Sociales y Culturales. This organization has partnered with CDM and AFL-CIO Solidarity Center in Mexico to establish RADAR, a program that seeks the eradication of labor rights violations against migrant workers during recruitment by focusing on joint responsibility of recruiters, employers, and other actors in the supply chain. And last, we have the United Food and Commercial Workers Union. This organization established offices in Mexico City to support migrant workers recruited legally through the Mexico-Canada Labor Agreement. And the last 2 that we are going to highlight have to do with also leveraging NAILC, but for union democratization issues. Here, these 2 organizations were instrumental due to their frequent participation in the ILO to create awareness about Mexico's ghost unions and the weaknesses of a tripartite system that is frequently biased towards employers. Here we will highlight Frente Auténtico del Trabajo, the FAT. This organization is conformed by several independent labor unions with holistic labor organizing models that includes right to the city perspective, such as neighborhood organizations and worker cooperatives. They have been active denouncing the failure to uphold freedom of association in Mexico until the Mexican Congress passed a constitutional amendment to guarantee secret ballots in union elections just 4 years ago. And last, the Comité Fronterizo de Obrera, CFO, like supported by American Friends Service Committee. This is a border network, and it's also a worker center that is based in Piedras Negras that mostly supports women working in the maquiladoras. Then next slide, Shannon, please. Then as you can see, these differing sides of cross-border advocacy touch upon multiple issues. We observe variation across region. And for example, we see less density of formal organizations in Central America and Mexico compared to the number of organizations that are based in the US. We also observe power and funding imbalances, especially in Mexico. We see that there is a lack of horizontal relationship. And this lack of horizontal relationships shows difficulty of building trusting and equitable partnerships among diaspora serving organizations that are working across borders. We also see that there is weak enforcement framework in both sides. And this weak enforcement framework breeds impunity. This mostly happens in the US, in the ecosystem of worker rights for migrant workers, but also happens in Mexico during recruitment. For example, UFCW has worked as whistleblower to bring awareness of Mexican Labor Secretariat staff as part of the corruption system that supports blacklisting of workers participating in the official Mexico-Canada Labor Agreement. So we see this paradoxical policy framework that are facing immigrants in which simultaneously are both subjects of rights, but also are subjects of punitive actions. Next slide, please. So then we have this litany of challenges that we heard from all these advocates that includes funding constraints, opposing goals amongst transnational advocates, especially security concerns, because for example, CDM had to move from Zacatecas to Mexico City due to issues of insecurity. The corruption amongst local political leaders that extends like upper cabinet members in Mexico City, but also at the state level, and also the double divide in which labor versus NGOs always have to navigate this soft law matters, that it's important, but mostly for supporting capacity building on the ground. And how they have done this is by installing local organizations interested in labor advocacy. But we also notice that a significant labor union organizing drive that is sponsored by Canada or the US towards Mexico and Central America has yet to be seen. So these are some of the things that are like important. So like last slide, Shannon, because like time is up. So the last thing that we want to close by what Shannon started is that we really observe the dual target strategies in some sort of double boomerang effect are the most important because they are followed simultaneously by labor advocates across borders when they are targeting more than one state, either Mexico in the US or Mexico in Canada. And these are the ones that are more likely to lead towards positive outcomes. And we will be happy to take questions at this point.
Excellent. Thank you all for your perspectives. I've learned a lot listening to you. I have a ton of questions, but I think I'll start with Nick. If you want to pose one question, then we have a list.
Sure. Professor Jimenez, I was thinking about your conversation about immigrant policy at the state and local level. And a question that obviously comes up a lot of time in many areas of law is which government bodies and level of government is best suited to enact policy. So kind of to follow up on your conversation about that, the action in immigrant policy is at the state and local level. Do we need a federal immigrant policy? How do you see that interacting in the possible, pros of having it, or do you think that the state and local immigrant policy is working better?
That's a great question, Nick. The short answer is yes, I do think we need a federal immigrant policy. I think that at least in the near term, the federal government should be supporting local efforts and playing the role of more of a convener, organizer, and disseminator, and possibly financial supporter of local policies. The immigrant population is incredibly varied. The places they settle is incredibly varied. And so the needs of a sort of integration process in a place like Houston is going to be different than it is in a place like New York or rural Iowa. And so I think there should be some flexibility in how those policies get implemented. There are some things that I think everyone agrees is important and beneficial to immigrants and the places they settle. English language acquisition, not the drowning out of the languages that people come to the United States with, but rather sort of English plus is a benefit to immigrants. It's a benefit to the place they settle, and so I think that's a place where the federal government could step in and support local efforts, and they've done some of that. So the Biden administration, as they have done with their citizenship test, has reestablished their Office of New Americans and Task Force on New Americans. I was about to say that the hope of many advocates, including an organization called Welcoming America, is that they establish an Office of New Americans that would do a lot of the work that I've just talked about. And I think this in some ways speaks to Xóchitl and Shannon's work, but there is a network of NGOs and NGOs that are working together to trade best practices, that are working together to support each other, and even financially in these kinds of efforts. So there is a sort of national effort. It's just not being necessarily led by the federal government.
Thank you, Professor Jimenez. Let me pose a couple of questions for Professors Bada and Gleeson, as well as Professor Elias Burch. Let me start with the last presentation. So this is so interesting to me, and I'm very much looking forward to the book. But I wonder if you could say a little bit more about the detail of the argument, in the sense that that's where the angel or devil will be, right? When you talk about it or seeing the presentation right now, it seems as if what these organizations are doing is negotiating or somehow reconciling nation state frameworks, or that could be a reading of what you're doing. But I sense there's more here. So what's the transnational part of this? Where are states being, or trans state, I guess, right? Where are states being transcended? So that's one question for you guys. And while you think on that, let me just throw one out for Professor Elias Burch. As you can see, there's a question also about your work that asks if you think that the Biden administration will reduce the age necessary to pass the exam in Spanish language among long-term permanent residence holders who are illiterate, one. And then part B for me, I'm adding a little piece of question there. You talked primarily about the content of the tests and the way that they probe citizens or American character. They probe for American character. But I wonder if you also had any opportunity to do work on the administration of the test itself. I too am a naturalized citizen, and I remember going into an interview and the officer having a very big American flag tie, which was a huge cue to me that some of the questions that he was going to pose, I should answer in a particular way. So if you have any perspective on that, maybe we can start with Bada Gleeson.
Xóchitl, do you want to answer, or do you want me to start? Oh, you're on mute.
You're muted.
I can briefly answer, and then you take it from there. Well, basically, I just want to point out that the idea of the portable justice framework is to deploy actions that go beyond the idea of methodological nationalism. So this is like going beyond discussing exclusively assimilation as the locus of action, both for immigrants and for diaspora serving organizations. So we are mostly like thinking that organizations, the NGOs, are tied into which defending frameworks of rights for the immigrants that they are defending in a circumscribed space. And here you have diaspora serving organizations that are frequently diaspora-led or migrant-led, that are activating multiple trinational and transnational spaces, depending on the scales of jurisdictions in they want to intervene. And they are activating these boomerang effects simultaneously and increasing the frameworks of action. But the portable justice is for individual rights, for labor rights, but the arenas of action of these immigrants that are both from here and there. It's like that, like Shannon began by saying ni de aquí ni de allá, but it's like to the contrary, they are both from here and there. They are not an either or proposition. They are equally invested in multiple states in spaces.
I'll just add a couple of things there. It's interesting because, we could continue the what is transnationalism really debate in sociology for another couple decades if we'd like, but I think it's a relevant question, right? What is so transnational about this? And I would submit that these organizations are not necessarily challenging the notion of the nation state. There are some groups that are kind of in open borders and all the rest, but that's not necessarily the tenor of these. These are largely lawyers and social workers who are submitting that there are borders and that there are rules across. But I would kind of point to three ways in which I would say, in which Portes et al. Might agree that there is transnational behavior happening. One would be in terms of just the funding and the organizational capacity that's happening here. The cross-border flows often of rich gringo philanthropists in the North sending money south is, I think, a very interesting puzzle that we're trying to kind of unfold. And so there's that element of it into how the funding flows cross-borderly and how the organizational capacity, not with all of these organizations, but with many of them, are creating relationships and networks on both places. The second has to do with bilateral agreement. So actually interjecting for example, labor side accords into the conversations around the renegotiated USMCA, so Centro de Derechos del Migrante, their latest petitions that they filed on behalf of H-2A workers very much was kind of talking about the rights of migrants in the United States before, in the context of these bilateral negotiations, and now kind of mobilizing those efforts in this kind of bi-national space. And the last I would say is the kind of iconic example of this has to do, again, with guest workers, although not exclusively, which has to do with thinking about labor processes as not necessarily starting and ending at the border, but in fact, looking at the labor recruitment that's happening, the pre-departure training that's often done to try to help people get a sense of what fraud looks like, and holding local officials in small towns in Mexico accountable to the both visa fraud and recruitment practices that are happening largely to send labor north. And so these are, I think, some examples of this, but I agree we could debate how successful they are, how transnational they ultimately are, and how sustainable they are. All things that we are grappling with ourselves. So I'll turn it over to the other panelists.
And so shall I answer the two questions that you posed? So very quickly, Professor Bada's question relayed by Professor Cook-Martin about whether the Biden administration might reduce the age necessary to pass the exam for certain naturalization applicants. By regulation, there are a series of exemptions to the testing requirements on the exam. So if individuals have reduced capacity, either because of a specific disability or because their age and their duration of residency. So there's a complex formula that's used to calculate who gets an exemption and who doesn't get an exemption. And a quick fix, some low-hanging fruit, would be to expand eligibility for the exemption. That that is absolutely right, and I'm hopeful that people will look at that. But I, as you may have gathered from my presentation, think that we need more of that. I think we need more than that. We need to think about whether we are trying to measure prior assimilation, to borrow Professor Jimenez's use of the word, or if we want to incentivize integration. Do we want to provide instruction, education, outreach to newcomers about American history in all of its complexity and its civic institutions in all of their complexity at the very end of an immigrant's journey in the US or at the beginning? Do we want to have a formal test at all? Has the process proven to be so deeply flawed that instead of requiring someone to sit a test, we should provide them with community college education on this topic in the hope that they will actually retain more information about the country than they would through memorizing 6 answers to a test? I don't know. It's a much bigger question, and I, as you can tell, could talk about it for another half an hour. As for the question about administration of the test, it's incredibly hard to collect information about test administration because immigrants are not allowed ordinarily to take another person into the room with them when they undertake their naturalization test. The exception is for legal counsel. Attorneys can sit silently in the room with their client in a situation where they've deemed that necessary. But otherwise, we're all guessing what's going on. And we know from other studies in immigration law, most famously, of course, Refugee Roulette, which looked at the disparity in grants of asylum in different immigration courts around the country, that the process is riven with subjectivity and discrepancies. So I would love to undertake that study. Professor Cook-Martin, thank you for the idea.
Excellent. Well, thank you for all of those responses. I think there's a question from Ken that I think Professor Gleeson and Bada have started to answer or did answer, but just in case, the question is, does what you do suggest that there's a transnational, that a transnational organization acts as a nation? So you can address that if you'd like. And then after that, I have another question for Tomas, and Nick may have some more questions as well.
how about maybe letting the others jump into some responses and we can loop back around?
Okay, so while you think about that, Professor Jimenez, you ended with a note about your most recent research and the upshot of that being that there were benefits of extending rights at the local level for both, U.S. Citizens as well as immigrants, and that that caught my attention, and I wanted to hear a little bit more about what you found, but also how you gauged benefits. What did you look at exactly? So, thank you.
Yeah, thanks for that question. I take this as just an opportunity to shamelessly plug a book that I think will be forthcoming with the Russell Sage Foundation, and my co-authors and I have published a couple of articles about this in Proceedings of the National Academy of Sciences, Social Problems, Journal of Social Issues. But so we were interested in. Stella mentioned that policies can play an expressive function, and we were interested in how individuals are receiving that expressive function. So not so much the administrative aspect of, say, welcoming policies, but what do they signal to the individuals who live under them? And so the outcome is really social psychological. So the benefit we're talking about is social psychological. And so we studied Arizona and New Mexico. These are states that have taken very different approaches to sub-federal immigration policy making. Arizona being the kind of quintessential least welcoming state in the union, and unequivocally least welcoming. New Mexico, a kind of pioneer in the more welcoming side of things. There are states that have gone beyond New Mexico and how welcoming they've been since New Mexico kind of jumped on the scene, but New Mexico nonetheless on the welcoming end. We did a big survey. We did an experiment where we primed half of our respondents. Our respondents were foreign-born and U.S.-born Latinos and U.S.-born whites. Primed half of all of our respondents to think their policymakers were considering making things more welcoming, and we gave them examples of what that would look like. And then the other half got it was sort of two treatments, but the other half were primed to think that things were going to be less welcoming. And then we asked them a series of questions. There's a social psychological affect question about whether it made them angry, sad, or happy, and we combined that into an index. And then we had another series of questions asking whether those policies would make them more likely to move and whether they made them feel less at home in their state. And then we combined those into an index. So those were our outcomes. And so when I say the benefits of welcoming policies are broad-based, the benefits show up in these kind of social psychological measures. This is saying nothing of the practical benefits that attain to immigrants and their families when they have driver's licenses, when they can pay in-state tuition, when they don't have to worry about local law enforcement, stopping them because of a their license plate is improperly illuminated, and that sort of rolls into detention and ultimately deportation. And so we have those kind of accounts from our in-depth interviews, but in the interest of time, I'll stop there. But please do buy the book when it comes out.
We have, I think, time for one more question. And Professor Chen put a great question in the chat that I was also interested as somebody who comes from a legal background. Why is citizenship and integration more the domain of social scientists, especially sociologists, than it is lawyers, or is it?
So Professor Chen suggested that perhaps I could take that question. And I feel like the answer is, it appears to be more the domain of social sciences rather than lawyers in the United States, but that is not the case globally. And in my own work over the last decade, I've written a couple of articles about immigration federalism, refugee federalism in the United States, so integration at the local level of immigrant communities, and a couple of articles about integration and the law globally in comprehensive immigration reforms in Europe and Commonwealth countries, in addition to the United States, and language rights in Europe and integration around language access. And the European literature is written by lawyers, and the American literature is written by social scientists. And I think part of the story is that so much of integration, as Professor Jimenez has explained, and assimilation and inclusion happens in the United States at the local level. Because of Plyler versus Doe, where immigrant children are entitled to K-12 education, so much of many immigrant communities' first point of access to civic society is through children in school and through other local initiatives. And immigration law in the United States, immigration and nationality law, is federal law. And since the early days of the plenary power doctrine and Chinese exclusion, this has been a feature of the legal landscape in the United States. Whereas in other countries in the world, immigration legal decisions, not just alienage law decisions, are made at a more regional level. And so I think that feature of the American immigration law landscape has affected our approach as legal scholars to this topic.
Thank you all for a wonderful panel. I wish we could go on. I still have a lot of questions. There are some questions in the chat that, especially Stella, you may want to look at. But thanks again. And I think we are ready to transition to the next stage. So Suzette.
Great. Thank you, Professor Cook-Martin. I appreciate that. Excellent panel. I love that last question. It really does go, I think it's so spot on given the interdisciplinary nature of the conference. Sort of why are we in these silos and what areas, why in some countries they're different than others. Is it a legal question, a sociological question, or something else entirely, a political question? So I so appreciate that. And thank you everybody for your contribution. I'm going to ask our panelists at this point if they can leave our current Zoom room. And we're going to be taking a 15-minute break. And so we will be resuming then at 2:45. So for those of you who are participating, get a snack, take a break. We will join with panel number 3, which is going to be our last panel for the day, entitled Non-Citizens Exclusion and Enforcement. For those of you, just a quick reminder, if you want to see just the rest of the schedule, you can check out the link that gives you the program that has the bios and information, how you can get in touch with folks and so forth. So feel free to check that out. We also have a reception that will be taking place at the end of the day, a virtual reception. So we're hoping that will be successful, but we're going to do a breakout rooms and we will provide a link for you in the chat so that you can join us at the end of the day. It will be a long day of presentations for sure. And so if you have a little bit of energy left, we would love to have you just join us informally in one of those breakout rooms. Just to do a deeper dive in terms of some of the things you may have heard and to join the conversation or to learn how you can put some of your ideas into action. So we have people who are working hard in that regard and you may decide to join them. So that will be happening around 4:00 Mountain Time. So at this point, please enjoy the 15-minute break and we will be back at 2:45 for our last panel. Thank you very much.